Hi, thanks for watching. Okay, so this is part two of the Courtney CLENNEY. This is the OnlyFans model stabbing case out of Miami, Florida. Um, in this video, I'd like to focus on the legal analysis of this case. Okay, the last video I did was sort of a psychological analysis. Okay, and the reason why this video is number two is because in this video, we can see how many times the way the law is set up, okay, the defense is forced to litigate the case sort of in a world of legal fiction, okay? Or maybe we'll have to litigate the case in a little more artificial manner as opposed to directly on what we all know are the true facts, okay? From the last video, I think most people can see that if Courtney doesn't have borderline personality disorder, she at least has severe behavior regulation issues, okay? Plus, she has severe rage issues, okay? In other words, she has these extreme, she has this volatility in her moods where she can get into a rage state where it's almost like she just goes blind with rage and she just apparently just loses control. Um, so she doesn't look like a person who is just cold and calculated and just coldly calculates and decides to be violent. She gets into sort of a very unsober, sort of excessive rage state. And it's almost like she just starts flailing around physically. And, that to me speaks of a mental condition. Okay. But the way the law is set up, it's exactly that kind of mental condition. Okay, as long as it's short of the extreme insanity that the U.S. law requires generally. Um, for those of you who are not aware, there's a thing called the McNaughton rule in the United States. It's basically applies in almost every state in the country, and it applies also at the federal level. You can only really make an insanity claim in a criminal case when you are so crazy that you don't even know what you're doing. In other words, you have to be completely psychotic in order for that to apply. So when you're dealing with somebody like Courtney, who has a rage problem, who has a behavior regulation problem, um, it's exactly that kind of mental condition that the law does not accommodate. Okay, so then at that point we start entering into a fiction because the law, even though the law says that there's a certain mental state for committing murder, the law also says that we will only consider an insanity defense if you are super crazy. Okay, so in other words, all these normal range mental conditions where people have behavior control issues or rage problems, the law says, as a question of policy, as a matter of policy, the law says no, we're not going to consider that. So then the law starts becoming artificial. Okay, in other words, the law no longer tracks actual reality. So even though if I were a lawyer, I would want to try to explore a defense based on her mental condition. Okay, the law really doesn't allow that, and so that may be why the defense is sort of forced into nothing but the self-defense tactic, and also they're going to bring up things like the battered spouse because it all fits in. It's basically the only thing that's available under Florida law. So in the rest of this video, I'm going to sort of take you through the steps of how, like, say, somebody like me, how I would research a case like this and how I would, let's say, give advice to an attorney, since I do work as a consultant in these kinds of cases. And so I'll sort of take you through kind of how I would analyze a case like this and why the defense that we see presently is pretty much the only defense that's available. Okay, so when I get a call or an email about a new case, especially if it's like a homicide or something very seriously, normally the lawyer already kind of knows the law and sort of knows what they want to do. But usually, what I'll do is I'll do research and I'll provide like a memorandum with, like, say, a couple of suggested strategies. And basically, the lawyer has probably already thought of those strategies, but it's just a way of confirming the strategy. So most lawyers already know, but before they even research, just from their experience, they kind of already are pre-programmed to sort of know how things are going to go. So when I get, let's say, consulted on a case, the attorney pretty much has, like, say, 95% of an idea of where we're going. So mostly what I'm doing is either confirming or I'm just double checking everything just to make sure there isn't any surprise in what the law says. So, you're not in a situation where you're discovering things for the first time or you're inventing the wheel for the first time. It's basically, it's like 95% certainty, and you're just kind of just verifying and just double checking there aren't any surprises in the law. Okay, so The first thing in a case like this that will be apparent to any attorney, just because of the nature of this being a domestic situation, but even before the charges come out, okay, even before, let's say, the state attorney actually issues charges, okay, you pretty much know this is a second degree murder case, okay. Although I will say, if I were a state attorney, a prosecutor, okay, I would pay close attention to the delay between the actual stabbing and the calling of 911. Okay, because if you are a prosecutor, that's a sign that you really want that guy to die. Okay, so I don't know that that would also, I don't know if that would either go all the way to first degree, but that might be a way. Like, say, if I was a prosecutor, that might be a way that I could get the mother as a like, say, as a conspirator. I could get the mother as conspiracy to commit second degree murder, um, or attempted murder. Okay, because maybe the mother was sort of collaborating on the phone to get some delay to call 911. So, like, say, maybe if I were prosecuting this case, I might have gotten the mother also as a co-conspirator, just to maybe force them to plead guilty, maybe to something quick. You know what I mean? Anyway, that's kind of the theory of bargaining. You want to bargain really high, and then you accept a lower price. So that's kind of the first thing I noticed about this case. But then again, in the United States, how often do you see someone charged for delaying a 911? I'm just saying I would put that on the table because that's like the one aspect of this case where it almost gets close to first degree. Okay, but we'll leave that aside. Okay, when you have a domestic case like this, it's clearly in the second degree murder category or possibly manslaughter, just depending on the circumstances. So you already know where this is going. And you also already know in Florida law that you're basically looking at self-defense. Okay, and I'll explain why. Okay, so the first thing we're going to look at is the definition of second degree murder. Okay, now with this statutory language, okay, you can see that it's already presumed that when you have a second degree murder, okay, there's no actual intent to cause death. Okay, that's the first thing. Okay, so it's always going to be, you didn't really intend to kill somebody, but you did something that was so dangerous, so clearly dangerous, and something that reflected such a total disregard for human life. Okay, so it's more than just reckless. It's like total disregard for human life. Okay, if it was more on the reckless side, you're getting closer to manslaughter. Okay, so basically, there's no intent to cause death, but you do something that's incredibly dangerous. Okay, that's imminently dangerous, and then something that shows that basically you have what they call a depraved mind, which means you're just acting without any consideration for human life. Okay, and so depraved mind. I mean, it's sad that the law has to be written like by poets. There's no reason for poetry in the law because who's going to interpret depraved mind? But it just basically means you're acting with like the lowest form of like human conscience, and basically you're just showing no regard for human life. So that's basically second degree. If it's more on the reckless side, not so horrible, then you're in manslaughter territory. So, believe it or not, when you work in criminal defense for a certain amount of time, you realize that it's actually pretty common. I mean, it's not totally common, but it's more common than we'd like it to be. That there are a lot of, like, say, spousal or boyfriend girlfriend stabbings that occur often with like a kitchen knife. I mean, that's actually kind of common, So lawyers are already kind of prepped for that in a way. It's not really unknown to a lawyer, this kind of situation. But it really tracks the elements of second degree because you take a sharp, like a steak knife or like some kind of like butcher knife from the kitchen, you start brandishing it around, you satisfy immediately the first element of second degree murder. Okay, doing something that's imminently dangerous. Okay. Secondly, if you're in the middle of a fight and you start actually brandishing this weapon, basically telling your boyfriend, "Hey, you better not get close to me, or you're gonna, or I'll have to do something." You're already starting to do something that shows that you're not really taking into consideration, you're not really showing the proper regard for human life. Okay, so those are really the two elements of second degree murder, and they do fit the typical spousal or domestic case where somebody picks like some scissors or a sharp knife or something like that. It's kind of a typical setup for second degree murder. And then finally, as we see the last part of the statutory language, we get into one of my pet peeves working in the law. And this is something that's really bothered me. which is that even though second degree murder is a lesser form of murder, it is regarded as a first degree felony, at least in Florida. Okay, which means that you can be subjected to a life sentence. Okay, and that really bothers me because I really think that a life sentence for a second degree, first of all, I think it should be a second degree felony. I mean, I don't know. That's just my opinion. I just think that, because you're not really trying to kill somebody, I just think that, it's kind of like it's like glorified manslaughter. I just don't feel good of sentencing people to life imprisonment for second degree murder. It's just a pet peeve that I have. And if the state really wants to put people away for the rest of their lives, why don't they just do the hard work and just figure out a way to charge them with first degree? You know what I mean? So it's just a pet peeve I have, but it's a serious charge. And basically, the only way you can get, like, say, kind of a short sentence is you have to kind of work really hard at sentencing, and that's where the psychological stuff will be allowed in. Okay, but as you'll see in Florida and in other states are just like Florida, but as you'll see in Florida, there is some specific case law that basically forecloses any kind of real psychological defense short of the McNaughton rule, which basically covers just like total insanity. So if you're not suffering from complete psychosis, complete insanity, basically, you're not even allowed to present evidence. Okay, believe it or not even allowed to present evidence that you had maybe a reduced capacity. Okay, now there are some other ways that you can maybe fail to meet the state of mind. So then you get into areas like intoxication, and you'll find that intoxication is allowed, but it's only allowed if the drug actually makes you the equivalent of being completely insane. So basically, it's just that radical insanity defense that's only that is allowed. And anything short of that, like say having borderline personality disorder, or having rage control issues, or let's say even being intoxicated, essentially those things are not allowed unless you're completely insane. And even then, Florida has an additional legal fiction, which is that if you're voluntarily intoxicated, and this is true in other states as well, but if you have voluntary intoxication, then you can't even use that, even if you are completely insane. So, a lot of legal fictions, because now the legislature is sort of carving the law out because of policy, because of public policy, in such a way as now we don't even care what the truth is. Okay, we're not going to hear certain truths. Okay, and you have to ask, why do we do that? And basically, if you read the case law, let's say the seminal case law on these policy decisions, basically what the courts are saying in so many words is that, look, if you look at the prisons as they are, probably most people have borderline personality disorder. Probably most of those people have rage issues. Okay, if you start allowing, like, say, evidence of a person has a rage problem, or they have an anger problem, or they have a personality disorder, essentially what you're going to do is you're going to open the floodgates, and every single defendant is probably going to be able to argue some level of that. So basically, we're kind of admitting the truth that we don't really want to admit, which is that most people who commit crimes don't really commit crimes with a sober mind. Okay, when I say sober mind, I don't just mean not taking drugs. I just mean if you have such rage, or if you have like anger management or behavior control issues, in a sense, you don't really have a sober mind like a normal person does. But that's just the way the law works. And so basically, at this point, we have to move into fiction. Okay, or we may have to move away from the truth, and we may have to sort of adapt to what the law does allow, which may not be exactly the truth. And so, if I were on the defense team for Courtney, on Courtney's team, okay, another landmine we'd have to watch out for in this area of maybe not being allowed to litigate the truth, okay, is the fact that if Courtney was the first aggressor, okay, if she was, let's say, escalating the fight by pulling out the butcher knife, okay, if you could say that, okay, then she loses her eligibility for even self-defense, except under very strict exceptions. Okay, so in other words, you start closing the door on self-defense, even if there really is a true self-defense situation. If she is the first aggressor, she starts to kind of narrow that down. The availability of self-defense actually starts to narrow down. Okay, so that's something to think about here, and I think the state may pick up on that. Okay, in the way this fight was progressing, okay, it maybe started off as the average fight, but then at the point she grabbed the knife, you could say that maybe she escalated. She escalated the fight. Okay. So then now she's under much stricter rules to even be able to offer a self-defense strategy. So again, when I get called or I get an email for a new case, generally the attorney I work with already knows the law pretty well. Okay, so I'm just there to kind of research just for anything, any surprises, or just to verify it pretty much, and also just to maybe do some double thinking about the strategy. But the lawyer pretty much knows what he wants to do. So I'm thinking that the lawyer that took this case probably knew the ABCs of second degree murder. This is kind of the ABCs. This is not really advanced law for Florida. So they probably already understood that, any mental health issues that can only come in at sentencing. Okay. And that basically the only thing they can work with really in a case like this would be self-defense. Okay. So let's look at the self-defense statute. Okay. In Florida, basically self-defense is it's an allowable defense. Um, Whenever you have a defendant that is in a situation where they reasonably believe, okay, that they could either be killed or suffer great bodily harm. Okay. But the key phrase is reasonably believe. Okay. In other words, if you happen to have PTSD or battered spouse syndrome, okay, that may help us understand why you believed you're in danger. Okay. But then there's the other requirement, which is reasonably. So even if you have PTSD, even if you are a battered spouse, it still has to be a reasonable fear. Okay. And that's another thing. In Florida, you're not allowed to use either the battered spouse or the PTSD to override the basic standard of self-defense. Okay. A reasonable person also would have to agree that you are either at risk of either losing your life or suffering great bodily harm. Okay. So lawyers pretty much know that. Okay. So any lawyer that I work with is not going to call me to verify that kind of stuff. This is ABC stuff. Okay. So any lawyer just off the rack, pretty much, who has maybe 10 or 15 or 20 years experience doing criminal law, all the stuff that I just talked about is just common knowledge, basically. Um, so I don't really get called for this kind of analysis. I would get called for maybe something more of a twist in the case, basically. But basically, if I am part of this team, we are going to be going over all these elements. Okay. And so by the time we make the first recommendations to the family, okay, we already kind of know the outlines, and we already kind of know what's not going to be allowed let's say at the guilt phase. Okay. So in a case like this, it's very interesting because just a few days after this incident, it's interesting how Courtney ended up going to Hawaii specifically to get treated for PTSD. Okay. Because that perfectly fits kind of what's allowed. Okay. In other words, if we're dealing with the truth, she might have gone to a hospital to deal with her borderline personality disorder, right? But notice how there's not a mention of that, right? Because that's not going to help. Okay, that's not going to help at the pre-sentencing stage. Okay, so you have to start labeling things a certain way, and the law basically forces us to go in the direction that may not be the truth. Okay, I'm not saying that Courtney doesn't have maybe some PTSD. A lot of people with borderline have complex PTSD, but I'm just saying that you just have to kind of swerve away from certain things, even though they might also be true. So the borderline is kind of like, we're not going to talk about that in terms of, like, say, the guilt phase. Um, and so you'll start to hear like buzzwords, like PTSD, and then later you'll hear things like the battered spouse syndrome, because these are all the things that are allowed. Okay. And then finally, even though Courtney did mention, even in the police interviews immediately after the incident, she did mention there were some moments where Christian actually did get his hands on her and did kind of restrain her. And she says choking. I mean, is that going to be corroborated? I mean, because we've seen all these other videos of all these other fights, and it just looks like Christian, he does get frustrated, and sometimes he does grab her to try to calm her down. But I don't know that I've seen anything that looks like choking, so that would be kind of something different. And I don't know that she's going to have a lot of corroboration. I think the only other witness who might corroborate that might be her mom, because she was on the telephone. But basically, you can see how the defense already has to kind of commit to that, even though that doesn't really fit their historical pattern. Okay, that we've seen the historical pattern of Christian and Courtney. Okay, but even though we know the historical pattern, the lawyers are sort of forced to go with, okay, you said he choked you. Okay, we have to go with that, right? They have to go with that, right? But the problem is, and we all know this, is that this is not going to be corroborated I don't think you're going to find a lot of witnesses to corroborate this. Okay. The only corroboration we're going to find is maybe just bits and pieces. For example, I think just a few weeks or days before this incident, shortly before this incident, I think there was a situation where the police were called on a domestic call to the building where they lived. And I think one of the building employees at the lobby actually told the police that in this instance, Christian actually kind of approached her in an aggressive way. Okay. So you're going to get little flickers of evidence from certain people that show that maybe on occasion Christian could be a little more aggressive. I think there was even a neighbor who saw them up from a balcony, and where his apartment was located, and I think he saw them walking down below and saw Christian being more aggressive at one point. So this is all very circumstantial. None of this directly corroborates the claim that he was choking her on that particular in that particular situation. Okay. Um, so, if I were analyzing this case, okay, if it were up to me to give, like, say, a memorandum, a strategy memorandum, okay, I would say that we have to argue self defense, number one. I'd say we have to. And I'd say number two, it's a weak argument. Okay, so yes, we have to. And number two, it's a weak argument. Okay, because there's just not a lot of corroboration. Her claim about the choking tends to go against what we've seen. Okay. Also, the police got a chance to examine her closely, in just in the minutes and hours after the incident, right? And I didn't notice any big choke marks on her neck, and I think they even probably took a lot of pictures of her, right? So there's probably a lot of forensic evidence that shows that if there was any choking, it wasn't enough to leave any bruising or any marks or anything. So, it just doesn't look like a super strong argument, but you have to argue it, right? I mean, that's just all she said, in her excited honesty, right after the incident, she said that he did choke her a little bit. I don't know, maybe it's true. I'm just saying it's not a very strong assertion, because it doesn't really match their history. And I don't think you're going to get more than just a little bit of circumstantial corroboration. Okay. So you got a problem. It's a necessary argument. It's just not a very strong argument. So if I were writing the memo for the strategy, then what would be my number three to make it strong so I could sell it to the attorney so I could do my job? Okay. What would I argue? I would say make fireworks, make as many fireworks as you can, make this a firework litigation with lots of motions, lots of scandals, and just tire out the prosecution until finally they're willing to settle for something. Okay. What do we mean by fireworks? Okay. Well, there was the whole issue of the laptop, remember, where the family was trying to break into Christian's laptop or whatever. And so there was a big question as to whether they were, let's say, committing some kind of like federal crime by having unauthorized access to someone else's device, right? So there was a whole question of whether it was even legal for them to do that, right? And so then the prosecutor started kind of looking into the communications that Courtney's parents had with their own defense team, right? And so they started looking into privileged communications. So now the defense can make fireworks about the privileged communications, just whatever you can find. If it's not that, you make fireworks of something else. Maybe it would be how maybe the crime scene was analyzed, maybe some chain of custody issue or something, but just make a lot of fireworks, right? So they found something. They found that issue with breaking into the laptop where the prosecutors got into their, let's say, privileged communication. So they're going to shake the tree and make it sound like all these things are happening, and they're just going to have all these motions everywhere, because the idea is you just tire out the prosecutors because you want them to come to you, maybe say, hey, can we settle this case, right? Now, I have worked a lot in South Florida. Okay, that South Florida is actually where I've done most of my where I've had most of my litigation experience. Okay, so I know that ASA's office, right? And I know that when there's politics or when there is some kind of like notoriety or a lot of press or publicity around the case, they don't like to fold. Okay, they'll fold on other cases. Okay, they'll fold on the unknown neighborhood cases that don't make it to the news. But when it's in the news, okay, they would rather just spend the money and go to trial. Okay, so this is the kind of case where I don't expect the state to back down too easy. So what would be my number four in my strategy? Okay, at some point, I would bet that the defense is writing confidential letters to the ASA's office, right? where they're outlining like what they think is their position, what they think their strengths and weaknesses are, and maybe offering to the state, that they're willing to let everything go away and just walk away with like say a manslaughter plea agreement. That's what I would expect. Okay, now are we going to get there? I don't know. I don't really think so. I think the state has a really strong case. And so this is one of these cases where if you're an attorney, it's really hard to talk to the clients, right? I don't know how honest the lawyer can really be with Courtney's parents, but I think a really honest lawyer would say this is a hard case. This is a hard case. We have to I would say we really are in a position where the only thing we can do is bluff. The best we can do is bluff and get the state to accept a manslaughter plea agreement, and that's probably really all they really have. And then finally, once she is, let's say she is convicted of second degree murder. Okay. Then finally, the next step is a big step, which is where now you can use all the psychological stuff in sentencing. Okay. So at sentencing, you can hear about borderline personality. You can hear about, let's say, her drug problem, her issues with, difficulty controlling her behavior, lifestyle, that kind of thing. How much mitigation that is, how much you can reduce the sentence, it's just going to depend on the quality of the attorneys, and also maybe the quality of the expert witnesses, the psychologists, psychiatrists, that sort of thing. Anyway, but yeah, so this case is not a good one for Courtney, and it's because largely the way the law is set up, you're not allowed to litigate on the truth. Okay, you have to go into kind of artificial fiction, and they're sort of forced into this self-defense argument that really doesn't seem very credible, But there's really no other option the way the law is written. So as we close this video, okay, what are the two big takeaways that I have? Me being somebody who does work in the legal business, especially in criminal defense. So what are my big two takeaways here? Okay, number one, I see a lot of people like on YouTube and throughout all like the press and the media making this big deal out of the defense motions. Like the defense has a motion, let's say, to try to sanction the prosecutors, to try to disqualify the prosecutors, to try to make them pay some kind of penalty for violating the attorney-client privilege. Okay, it sounds so bad. But let's remember, they were in the course of investigating something very specific, which was possible criminal conduct in breaking into Christian's laptop. Okay, so the context there is kind of understandable. Believe me, courts will look into all those things. Okay, and also just remember, there's nothing magic in the law. Just like the way the second-degree murder statute is written, there's nothing magic about it. And in fact, the courts will apply that the letter of the law and kind of mold it to reality, the reality of public interest, And so likewise, you just can't shoot the prosecutor in the head and make them go away just because they made one mistake. You know what I mean? And so whenever you're dealing with a situation where you accuse the prosecutors of misconduct, not only does the misconduct have to be serious, okay, but also you have to show real prejudice, okay? So the only precious attorney-client communications that were actually invaded with that little, investigation into the CLENNEYs, it was specifically around trying to break into the laptop. So they can't really pretend like they got a peek at their core of the defense theory. That's not realistic. So if they could prove that, we already would have known about it. Okay, believe me, the judge would have already seen that, a long, long time ago. So, whenever you don't have like hardcore prejudice to the defense, largely what we're seeing is what I call fireworks. Okay, and it's okay. It's part of the job. I mean, part of doing your job is you need to make a lot of fireworks. Okay, and we're seeing the same thing with Corey Richins over there in Utah, making a lot of fireworks because hey, when you have a crappy case, you got to make fireworks. It's just guaranteed. It's just automatic. It's just part of the job. Okay, so that's one takeaway that I have. And my second takeaway is for those of us that do have personality disorders, for those of us that do struggle with behavior, like say with regulating our emotions, those maybe of us that have rage issues, if the law is not going to really accommodate us, like say at the guilt phase, maybe at the sentencing phase, but surprisingly, not even that much in the sentencing phase, to be quite honest. So what do we take away, those of us who have had personality disorder diagnoses, or those of us who do struggle with certain mental health issues? We're not going to get a lot of support from the law. And in some ways, we're going to pay a higher price than ordinary people because ordinary people don't have those kind of behavior problems, right? Um, so what do we take away from that, or what do I take away from that? I think that number one, life is not always fair. Living in a society is not always fair. The law is not always fair. um, and if any of us have issues with personality, or like say addictions or whatever, I think the best advice anybody with a legal background can give a person is you have to take responsibility for your personality disorder. Okay, if you, or even let's say you don't have a personality disorder, let's say you just have personality defects. Let's say you have a personality defect, one or two. Let's say you have a little bit of an addiction issue. We have to take that stuff seriously, and we have to take responsibility for it. It kind of sounds like, oh, take responsibility. It sounds so Republican. No, just take responsibility for it. Because really, nobody's going to take care of us in the end, especially not the court system. Okay. So it may be tough, and maybe sometimes life just gets too tough, and it's not like it's easy to find a great therapist or a great, like a lot of 12-step programs and stuff like that. They're not as good as they seem. Sometimes I've been to a lot of 12-step meetings, like say for addictions and stuff that I didn't feel were very good at all. So it's not always easy to find the support. But one way or the other, we just have to be like John Wayne, and we just have to, damn it, just take care of ourselves and take responsibility. So looking at this case, my biggest takeaway is I just didn't see Courtney taking really full responsibility for her issues. I know in her heart of hearts, I know that Courtney always knew that she had big time violence problem. She had a problem with her temper, with her rage. I know she knew that. Okay. And she was probably just a little too young, but even still, even from a young age, you have to really you have to be instilled with that value that you really have to take care of your character flaws. Okay. Because it will bite you. It will bite you, and so we have to be tough. We have to be tough because no one's gonna protect us. So that's kind of my big takeaway. And anyway, so I hoped with this video I could kind of give you guys a little behind the scenes. What is it like from the lawyer's point of view? I hope that was helpful. And I hope that I was able to offer sort of like a more realistic angle on how these things are dealt with and what lawyers actually go through. But in any case, I always do appreciate your patience with these videos, and thanks for watching. Talk to you later.